Hi, my name is Megan Jabori with JD Advising. During this video, we're going to discuss how to pass the multi-state essay examination, also known as the MEE. In this video, we're going to discuss an efficient approach so that you can be successful with the MEE. We're going to discuss the highly tested subjects, as well as the highly tested topics within each subject. It's absolutely crucial that if you are preparing for the MEE, that you are well prepared and well versed to handle questions that test those highly tested subjects as well as those topics within each of those highly tested subjects. The National Conference of Bar Examiners, that is the organization that writes the MEE examination, states that 14 areas of law are testable topics for the MEE examination. Those topics are civil procedure, constitutional law, contracts and sales, evidence, real property, torts, agency and partnership, corps and LLCs, family law, decedents' estates, oftentimes referred to as wills, trusts and future interests, conflicts of law, and secured transactions. It's also helpful to note that negotiable instruments is no longer tested on the MEE, so that's a topic that you no longer have to worry about. So while there are 14 testable areas of law or subjects that could make their way onto your MEE examination, our first tip is that not all subjects are treated equally. And by that, we mean that certain subjects are more highly tested than others. We've divided these subjects up based upon how they've been tested since February 2011 all the way through July of 2018. And we've divided these subjects into two tiers. Tier 1 illustrates those more highly tested subjects that we more commonly see on our MEE examinations. And Tier 2 are obviously testable subjects that you could see and you should be prepared to handle. However, it's less likely that they are going to show up on your examination. So let's turn to those Tier 1 subjects. So on Tier 1, civil procedure is the most highly tested subject on the MEE. Contracts has also made its way on Tier 1. Agency and partnership, corporations and LLCs, secured transactions, real property, evidence, trusts and future interests, constitutional law, decedents' estates or wills, and torts all make up Tier 1. Those subjects found on Tier 2 are family law, criminal procedure, and criminal law. It's helpful to note that these topics are tested and treated as separate topics. In other words, criminal law is a testable topic and criminal procedure is a testable topic. And lastly, conflicts of law is also on our Tier 2 list. It's helpful to note about conflicts of law that this is not a standalone testable topic. By that I mean, it's going to be crossed over or tested with a different topic. We most frequently see conflicts of law tested in the context of family law or civil procedure or decedents' estates. A few notes that may help you kind of better understand our bar examination frequency chart is that prior to 2014, the National Conference of Bar Examiners, those people who write our MEE examination, would draft anywhere from 7 to 9 questions and basically allow jurisdictions to pick and choose which questions that they were going to administer to their examinees. Starting in 2014, they stopped that practice and they would simply draft 6 questions. Therefore, anyone administering the MEE would have to administer those 6 questions. So that's something to keep in mind as you take a look at this bar examination frequency chart. This bar exam frequency chart has been color-coded so that you can more easily interpret it. And you can see that civil procedure is highlighted in yellow as it is the most highly tested subject on the MEE. And you can see those subjects highlighted in green make up the rest of that Tier 1 list that we've already gone through. And then anything highlighted in blue makes up what we were calling tier 2. Obviously, those subjects are testable. They're just a little less likely to come up based on how these subjects have been tested since 2011. This frequency chart is an excellent resource, something that you can refer back to because it illustrates to you what subjects were tested during which bar examination administration. So for instance, if you were looking to practice an agency and partnership question, you could turn to this frequency chart and see when they tested it. So while you shouldn't ignore any subject while preparing for the MEE examination, it's helpful and important to note that not all subjects are treated equally, as we've just went over. So it's absolutely imperative that you make sure that you are well equipped to handle those tier 1 or those highly tested subjects so that you can maximize your chances of success to pass the MEE examination. Our second tip to help you be successful on the MEE is to study smart. Do not treat all topics equally. We've already discussed the fact that certain subjects are more highly tested than other subjects on the MEE. However, many people do not know that the same is also true for topics within each subject. It's true that the National Conference of Bar Examiners does not necessarily reinvent the wheel every time they draft new MEE questions. And by that we mean they really like to test certain topics within each subject over and over and over again. Being comfortable with your outline on each of these testable subjects is really important, of course, to maximize your chances of success with the MEE. However, it's also very important that you take time each week while preparing for the MEE to look at old bar exam questions and to take time to analyze and to dissect the way they respond to those questions. Why? Because not every single topic is treated equally. You'll start to see that they test certain topics over and over again, and by looking at those old questions and answers, it will help you better prepare to respond to those types of issues if they come up on your bar exam. And that's not to say that they can't or won't test something else. It's just a really good, efficient approach to preparing for the MEE. So next, we're going to turn to each testable subject and talk about some of the highly tested topics within each. Turning to our highly tested topics within each subject, we're going to start with the subject of civil procedure. Civil procedure is the most highly tested subject on the MEE. However, we believe that there is a trend towards testing civil procedure less on the MEE. We believe that this is the case now that the MBE has started to test civil procedure. This change occurred back in 2015. So turning to those highly tested topics within the subject of civil procedure, those are subject matter jurisdiction, personal jurisdiction, as well as transfer to a more appropriate forum. Turning to subject matter jurisdiction, we find that if you know the basics, you'll be just fine with handling a subject matter jurisdiction question, as they like to test this issue in its traditional sense. Most of the questions that test this test subject matter jurisdiction in the context of federal question and diversity jurisdiction. It's also good to know that subject matter jurisdiction can be taken up at any time, even for the first time on appeal. Turning to personal jurisdiction, we find that personal jurisdiction is tested about once every 5 years. And there's a trend towards testing specific personal jurisdiction. If they're testing this, be sure to discuss the state's long-arm statute, as well as the fact that the 14th Amendment due process clause must also okay jurisdiction. Then from there, go on to discuss minimum contacts and purposeful availment and examine the quality of contacts that a person has with that place. And then turning to that third most highly tested topic within civil procedure, and that is transfer to a more appropriate forum. Transferring to a more appropriate forum is the idea that federal courts can transfer a case to another federal court for the convenience of the parties and the witnesses, and sometimes due to where the evidence is located. However, they can only transfer a case if the court in which they're transferring it to has jurisdiction to hear it, both subject matter as well as personal jurisdiction. Oftentimes, when the questions test this topic or this issue, the question is which law applies. And when a transfer to a more appropriate forum occurs, the law of the transfer or court will apply. This is not to be confused with transfer to proper venue. Transfer to proper venue has not been tested on the MEE examination. Transfer to proper venue is where someone files an action in the improper place, and it has to be sent or moved to the appropriate or proper venue. Under those circumstances, the law of the transferee court will apply. Turning to our next subject, constitutional law. So the highly tested topics within this subject are free speech, state action, the Dormant Commerce Clause, and Congress's ability to commandeer the states. So let's talk about free speech first. First and foremost, this is an excellent example of how going through past MEE questions and answers is very helpful. Typically, free speech gets tested in very similar ways to how it's been tested in the past. So by practicing old questions, it's an excellent way to prepare yourself for a free speech question. Sometimes, however, free speech has been tested in the context of a trespass or criminal claim as well. Turning to that second topic, state action. So state action, it's important to remember that you have to find a state actor if someone is suing under the First, 14th, or 15th Amendments. So remember, for example, that a company town is an excellent example of state action. And our third most highly tested topic within constitutional law is the Dormant Commerce Clause. So remember, Congress has the commerce power. So when states attempt to regulate interstate commerce, there are two tests we use to determine whether or not the law is going to be constitutional. If the state law is discriminatory, we apply strict scrutiny. If the state law is not discriminatory on its face, a balancing test is used, and it's more likely that the law is going to be constitutional. And then lastly, turning to the topic that Congress cannot commandeer or force the states to enforce federal laws. So it's good to remember that Congress has to either regulate the states directly, oftentimes using their commerce power, or they can indirectly regulate the states by using their spending power. Turning to our next subject, contracts and sales. The three most highly tested topics within this subject are Article 2 of the Uniform Commercial Code, contract formation, and damages. Turning first to Article 2, we find that about half of the questions that fall into the subject of contracts and sales are testing Article 2 of the Uniform Commercial Code. So if you find yourself with a question that's testing Article 2 of the UCC, start your essay by telling the grader that you know this and that you recognize the question is testing Article 2. Start by saying that you know Article 2 of the Uniform Commercial Code applies because it applies to all contracts for the sale of goods, and that goods are movable objects at the time of contracting, and that Article 2 of the UCC recognizes contract formation in any manner that's sufficient to show that the parties have entered into an agreement. The second most highly tested topic within contracts and sales is contract formation. These questions can be hard and tricky. They like to test the obvious, offer, acceptance, and consideration. But they also like to test the nuances, such as when does an offer lapse and the revocation of an offer. as well as things like the pre-existing legal duty rule. So it's really helpful to practice past questions here so that you can see how they like to ask these questions. And then for the third most highly tested topic within contracts and sales, that is damages. We often find that when they test damages, it can be the whole question. And this can be a struggle for students that have not paid much attention to this topic. So it's helpful to know the definition of expectation damages, as well as how to define the elements of expectation damages. Basically, it is the standard or default form of damages, and the whole purpose behind it is to put the non-breaching party in as good of a position as he would have been had the contract not been breached. It's also good to tell the grader that you understand that expectation damages must be foreseeable and fairly certain. Our next subject is criminal law and procedure. The first most highly tested topic within this subject is homicide. Being comfortable with homicide is so important for the bar exam. It's not only important because it's a highly tested topic on the MEE, but homicide is also going to make up 4 to 5 questions on the MBE. So it's a good topic to be comfortable with. On the MEE, oftentimes these questions are saying if you know the difference between first degree and second degree, and if you can articulate and analyze the required mens rea. So remember, for first degree murder, this can be defined as the intent to kill, or someone acting with the knowledge that their actions could cause death. Whereas second degree murder is more commonly defined as the intent to cause grievous bodily harm or extreme recklessness with regard to homicidal risk. Turning to the second most highly tested topic within criminal law and procedure is the Fourth Amendment. Remember, whenever you see a search or a seizure by government officials, talk about the Fourth Amendment. More specifically, the Fourth Amendment kicks in and protects people against unwanted searches and seizures done by government officials without a warrant in places in which they have an expectation of privacy. Usually, a warrant is simply required for government officials to be able to lawfully execute a search and seizure. But remember, there are exceptions to the warrant requirement, and these are often tested on the MEE. Some of those exceptions are exigent circumstances, search incident to lawful arrest, inventory searches, consent, the automobile exception, Terry stops, as well as the plain view exception. And the third most highly tested topic within criminal law and procedures is the Fifth Amendment and confessions. Now, it's important to know that the Sixth Amendment and 14th Amendment have also been tested in the context of confessions. However, the Fifth Amendment and Miranda is the most highly tested way that they like to test this issue. They like to test things such as when Miranda attaches. Here you want to discuss the buzzwords custodial interrogation. It's also helpful to be familiar with how someone can waive their rights, as well as how one must invoke their rights. In order to successfully invoke your rights here under the Fifth Amendment, if your question is testing this issue, please be sure to use the appropriate buzzwords. To invoke your right, you must do so explicitly, unambiguously, and unequivocally. The next subject we're turning to is evidence. The 3 most highly tested topics within this subject are hearsay, impeachment, and character evidence. Turning first to hearsay. Hearsay is very, very important on the bar exam in general. This is not only because it is very highly tested on the MEE, as we are about to discuss, but also because it's very highly tested on the MBE. You are going to receive 6 to 7 questions on hearsay alone on the MBE. So turning to hearsay in the context of the MEE, it's helpful to have a good working definition of hearsay. Remember that hearsay is an out-of-court statement offered to prove the truth of the matter asserted. And it's also helpful to be familiar with some of the more highly tested exclusions and exceptions. Some of those being opposing party statements, present sense impression, statements made for the purposes of medical treatment or diagnosis, business records, as well as the excited utterance exception. Turning next to the topic of impeachment. So first and foremost, remember that any party can impeach a witness. A lot of people forget that fact. Additionally, these questions like to test different impeachment mechanisms. Some of the more highly tested impeachment methods or mechanisms that we see tested on the MEE are prior inconsistent statements, impeachment by convictions of past crimes, prior bad acts, and then impeachment due to reputation or opinion for untruthfulness. Also, it's good to note that this is a perfect example of a topic where the NCBE does not reinvent the wheel. Twice now on two different MEE examinations, specifically on the February 2009 exam as well as the July 2014 exam, they tested impeachment in the context of someone lying on a resume. And they basically asked the same question, whether or not the actual resume itself could be admitted. And the answer is no, because the resume itself is extrinsic evidence and that cannot come in to aid in that impeachment mechanism. The next most highly tested topic within the subject of evidence is character evidence. And we frequently see character evidence tested in the context of criminal cases on the MEE. So a few things you should remember here is that character evidence is not going to be admissible to prove propensity or that someone acted in conformity with their character at a certain time. Additionally, character evidence is not admissible in the prosecutor's case in chief. However, the defendant has the ability to offer in relevant or pertinent character traits. In other words, they have the opportunity to open the door, so to speak, and they can do this with reputation or opinion evidence. Once this has happened, then the prosecutor can rebut that by also bringing in reputation or opinion evidence or by cross-examining the defendant's witnesses and asking about specific instances of conduct. It's good to know in the world of evidence that there's a lot of things that just simply haven't been tested. So for instance, things such as expert witnesses has never shown up on an MEE examination, or the best evidence rule, or judicial notice, or authentication. None of those topics have been tested on the MEE. And it's not to say that those things can't be tested on the MEE, but it just goes to show you and serves as another example that practicing past essay questions is an excellent way to prepare yourself to be successful on the MEE, as well as really focusing on those more highly tested topics so that you are less surprised and more well prepared to handle your MEE examination. Turning next to the subject of real property. The three most highly tested topics within this subject are deeds, recording acts, and leases. Turning first to deeds. It's helpful to know the 4 requirements to have a valid deed, such as the deed has to identify the parties, be signed by the grantor, have words of grant, as well as a description of the land. It's also good to be familiar with the different types of deeds that they like to test on the bar exam. And those are quitclaim deeds, which basically contain no covenants or no promises. And they also like to test warranty deeds, which are the exact opposite. Warranty deeds have both present and future covenants or promises. Also in this context, it's good to be familiar with the ideas of equitable conversion and its effect, as well as merger. The second most highly tested topic within the subject of real property are recording acts. It's good to remember the common law default rule, first in time, first in right, and to include this rule in your analysis of a recording act. The MEE really likes to test notice recording acts. However, it would be helpful to be familiar with race notice acts as well. It's also good to know what constitutes notice so that you can analyze it thoroughly and appropriately on the MEE exam. And then turning to our third most highly tested topic within this subject, and that is leases. So when we say leases are a highly tested topic, this means you should be familiar with the rights and the duties of both the landlord and the tenant. For instance, the tenant has an obligation to pay rent. It's also good to be familiar with different types of leases that exist, how they're created and when they end. So, for example, they once tested that periodic tenancies have no fixed end date. And then it's also good to be familiar with the concepts of constructive eviction and the implied warranty of habitability. The next subject is torts. The first most highly tested topic within this subject is negligence. Negligence is incredibly important for your bar exam in general because negligence will make up about 12 to 13 of your total MBE questions. So you should be very comfortable with negligence, not only for the MEE portion, but for the MBE portion as well. So for the essay portion, you want to be comfortable with all of the elements of negligence: duty, breach, causation, and harm. They also like to test premises liability, and you should be able to distinguish the different duties that are owed to different types of people, such as your trespasser, your licensee, or your invitee. The next most highly tested topic within the subject of torts is our intentional torts, specifically the torts of assault and battery. We find that when they test these torts, they really want the examinee to have precise, sound rule statements. So remember, the real difference between assault and battery is the outcome or the harm. So in other words, the rule statements are identical except for the harm that results. So a battery is when someone acts with the intent to cause harmful or offensive contact or imminent apprehension of contact, and harmful or offensive contact or imminent apprehension of contact directly or indirectly results. It's a battery if that harm directly or indirectly results, the contact, I should say, and it's assault if imminent apprehension results. And then the third most highly tested topic within the subject of torts is vicarious liability. This usually comes up when an employee commits some sort of tort, and the question is the employer liable, and whether or not they're able to get any money back from that liable or negligent employee. So it's good to know the difference between indemnification and contribution. Indemnification is the idea, again, often tested in this context of vicarious liability, where the employer is not liable at all, except for the fact that their employee committed some sort of tort. So this means that they can seek indemnification and get 100% of the damages back from their employee. Our next subject is agency and partnership. First and foremost, it's good to note that since agency and partnership is considered one testable subject, corporations and LLCs are considered a separate testable subject. And usually you'll see one question between the two subjects, meaning usually you'll get an agency and or partnership question or a corporation's or LLC question. You usually do not see a question on both of those subjects. However, I said usually, meaning there are exceptions to that rule. For instance, back in February of 2017, examinees sitting for the bar exam saw both an agency partnership question and a corp's LLC question. So what are those highly tested topics with an agency and partnership? First and foremost, they like to test authority. And you should be comfortable and know the differences between actual and apparent authority. Specifically, the fact that actual authority can be implied or express, and that apparent authority results when you have two elements. That the party dealing with the agent has a reasonable belief in that agent's authority, and the second requirement is that this reasonable belief is generated by some sort of action or negligence on behalf of the principal. They also like to test the concept of ratification. So this is when the agent acts without authority. However, the principal ratifies those actions and becomes liable for them. The second most highly tested topic within this subject is partnership formation. It's good that you are comfortable with not only general partnerships, but other limited liability forms, as you could see either tested on your MEE. If they are testing general partnerships, you could start out your essay by saying something like, a partnership is an association of two or more people who are carrying on as co-owners of a business for profit, regardless of whether or not they wanted to create a partnership. It's also helpful to know that the sharing of profits carries with it a presumption that there is a partnership, so long as that profit sharing is not being done for some other reason, such as the repayment of a debt. And the third most highly tested topic within agency and partnership is the ability of a creditor to collect against partners and or partnerships for debts. So first and foremost, if a creditor has some sort of claim against an individual partner that belongs to a partnership, that creditor can obtain an interest in the partnership itself. This means they can claim an interest in the money or in the profits, but they will not receive a management or voting rights. If a creditor has some sort of claim against the partnership itself, creditors can try to collect on their judgment against individual partners. These concepts are very highly tested, and we have found that they are often not covered or covered very little in most of your standard commercial courses. We bring this to your attention because they are very highly tested. So not knowing them or knowing very little about them is not putting yourself in the best position to be successful on the MEE examination. So what should you do? If you find yourself in this position, be sure to look back at old essay questions and answers. That way you can see how they ask questions, what they like to test, and what the appropriate response is. Additionally, you could check out our MEE one-sheets, which outlines in much greater detail, specifically in about 2 pages, all of the highly tested topics within each subject, and that's an excellent resource to help prepare you for this examination in general. The next subject is corporations and LLCs. The first most highly tested topic within this subject is the business judgment rule. You should talk about the business judgment rule when shareholders complain that the directors have breached their duty of care. It's helpful to have a good definition of the business judgment rule. The business judgment rule is a presumption that the directors have acted on an informed basis, in good faith, and with the honest belief that the action they are taking is in the best interests of the company. Directors are obligated to work or make decisions on an informed basis. This means they can rely on certain reports and opinions. They can also get advice and rely on the advice from people like attorneys and CPAs. If someone is claiming that the directors have breached their duty of care and you're discussing the business judgment rule and its presumption, it's good to know that this presumption is very helpful or favorable to the directors. This means that the people complaining, usually the shareholders, have the burden or obligation to overcome this presumption and to prove that the directors breached this duty of care. Turning to some examples on how they've tested the business judgment rule. The first example is from the February 2008 examination. In that fact pattern, they told you that the directors had a meeting and they discussed a very expensive contract for about 10 minutes. And they really didn't ask a lot of questions about cost comparisons or really anything at all. And they wanted you to know that under those facts, it's likely those directors breached this duty of care. Another example of how you could see the duty of care or this business judgment rule tested is from the February 2010 examination. And they tested this in the context of a shareholder challenging the board's decision to not pay out dividends. And it's good to know that it is very hard for shareholders to be successful in this type of challenge. Why? Because they have to show that the directors breached this duty of care. This means they have to prove that the funds to pay the dividends are available and that the directors acted in bad faith. That essentially translates to proving that the directors had their own self-interest first over the companies, which again is very hard to do. The second most highly tested topic within this subject are derivative versus direct lawsuits. So it's helpful to understand the difference. A direct lawsuit is when a shareholder is suing because they're claiming that some sort of harm has happened to them personally. And they're usually suing, the corporation and the board of directors. A derivative lawsuit is where a shareholder sues on behalf of the corporation to enforce the rights of the corporation. Again, usually claiming that the directors have breached one of their duties in some way. The third most highly tested topic is the piercing of the corporate veil, or the piercing of the LLC veil. A lot of people forget that the LLC veil, so to speak, can be pierced. And this is something that is tested a lot on the MEE. So please remember that. We can also pierce the corporate veil in closely held corporations. And this is basically when someone is injured and they claim that the owners of the corporation or the LLC members have abused the privilege of incorporation, and that they should be able to hold those individuals personally responsible. And then the last most highly tested topic within this subject is LLC formation. It's good to know the basics regarding formation, the rights, and the duties. Articles of organization must be filed properly in order to legally create an LLC. And since LLCs are a relatively new form, many states are kind of mixed on how they handle LLC issues. Some treat LLCs like partnerships, where others treat LLCs a lot like corporations. It really just depends. Remember that members of LLCs have fiduciary duties. Members of a member-managed LLC are treated as agents of the LLC. This means if they are acting with authority, they can bind the LLC in ordinary matters. The next subject is conflicts of law. You might remember from the beginning of this lecture, I told you that conflicts of law is technically a Tier 2 subject, meaning it is not tested as frequently as those Tier 1 subjects. And additionally, conflicts of law is not a standalone topic, meaning you're only going to see conflicts of law tested with another subject. We most frequently see conflicts of law tested with family law, civil procedure, and then wills or decedents' estates. So let's talk about how they like to test conflicts of law within those subjects. Turning first to family law. So the way they like to test conflicts of law in family law is they're usually testing whether or not if a couple has entered into a common law marriage in one state, if it will be recognized by the other states, say other states that do not recognize common law marriage. And here the answer is going to be yes. And this is because marriages entered into, even common law marriages entered into in one state, will not violate the public policies of other states and therefore will be recognized. When we see conflicts of law tested with civil procedure, they like to test the Claxton rule. And this is a good doctrine to be aware of generally because released MBE questions test this frequently as well. So it's something that you should pay some attention to. So what is this about? Basically, this whole doctrine states that when a federal court is sitting in diversity hearing a case, it is obligated to follow the choice of law approach that the state in which it's sitting in would apply. And when we see conflicts of law tested within the context of wills or decedents' estates, it's usually testing the issue of which state law applies to the distribution of personal versus real property of a decedent. So the laws of the state in which the decedent was domiciled at the time of death will prevail over their personal property. However, the laws of the state where the real property is located will prevail over that real property. Turning next to family law. So, the first thing I wanted to say about the subject of family law is that a lot of people tend to underestimate sometimes the difficulty of these MEE questions. I think a lot of people approach this topic as it's, rather common sense, or maybe they took a family law course in law school, which is great. But in our opinion, family law questions on the MEE tend to be a little bit trickier. And something else that we've noticed is that a lot of commercial courses, unfortunately, focus and go into great deal on things that are rarely tested or never even tested at all. For instance, we've seen a lot of commercial course outlines go into great detail about egg donors and marital rape. And those things are rarely or never tested at all. And then they go a little bit lighter and get into less detail about those more highly tested issues that do show up on the MEE. So just to be sure that you are preparing yourself adequately for this subject, what you should do is make sure you really take a hard, close look at past questions and make sure you really study the answers as well. And also get your hands on other resources if you find it necessary or if you find that you're struggling. For instance, our one sheets are an excellent resource that go over into some detail some of those more highly tested topics within each subject, family law included. So, what are those highly tested topics within the subject of family law? First and foremost is common law marriage. And to start, I'll start by giving you a little hint. Usually, if the MEE question asks if the couples have entered into a valid common law marriage, the answer is usually no. They're usually missing one of the elements that are required. So the elements that are required for a valid common law marriage is that the proponent or the person claiming that a common law marriage exists has to show that the parties had the capacity to enter into this marriage agreement, a present agreement to be married. The parties must be cohabitating with one another and then holding themselves out as being married. It's also helpful to know that if the parties have entered into a valid common law marriage in one state, that common law marriage is going to be recognized in other states as well. The second most highly tested topic within the subject of family law is custody and custody determinations. So first and foremost, custody determinations are based upon the best interest of the child. This is a multi-factor approach. There are a handful of different factors you should be familiar with here. It's also good to know that biological fathers do have parental rights, but it is okay or constitutional for states to usually require fathers to exercise their rights within a certain window of time. And then the third most highly tested topic within family law is the idea of alimony or spousal support. So first and foremost, it's good to know here that trial courts have substantial discretion in deciding whether or not they are going to award alimony. And some of the factors that you should be aware of and discuss if analyzing this issue are things such as the parties' financial resources, their marital contributions, as well as the marital duration. Other factors that some states look at and might be helpful to discuss on your essay are things like spousal misconduct. They oftentimes look at too whether or not a spouse supported the other in, say, furthering education or training, and things of that nature. Our next subject is secured transactions. We find that the highly tested topics within this subject are a lot of Article 9 basics, such as attachment, perfection, purchase money, security interests, and default. So first and foremost, we find that one of the most highly tested topics is knowing whether or not Article 9 applies to the fact pattern. And most of the time when they ask this question on the exam, the answer is yes. Article 9 does apply, even if the parties do not realize that Article 9 of the Uniform Commercial Code applies, and even if they do not use the words security interest in their agreement. None of that matters, and Article 9 can still apply. Specifically, it's helpful to write down on your essay answer that the Uniform Commercial Code, specifically Article 9, is going to apply to all security interests in personal property and fixtures. The second topic to be familiar with are the requirements of attachment. So what are those requirements? The first requirement is that value must be given. This is usually when someone goes to, say, a bank and asks for money. This means the bank must actually give them money to that debtor. The second requirement is that the debtor must have rights in the collateral in which they put up to secure this transaction. And then the third requirement is that the parties enter into a binding security agreement. To have a binding security agreement, you need AID, A-I-D. What does AID stand for? This stands for authentication. This means that the debtor signs the agreement. Your I of AID is intent. The parties must have, the intent to enter into this. This is voluntary. And then your D of AID is that there must be a description of the collateral. It's really helpful to go through this even just briefly on your essay examination, as it is so important and so highly tested. So this is not a topic that you just want to kind of forget or omit from your response. It's best to discuss it even if just briefly. The next most highly tested topic is perfection. So it's good to know that perfection can occur in a few different ways. Most commonly, it occurs by filing a financing statement. In some instances, perfection can be automatic. This is often the case with those purchase money security interests in consumer goods. Perfection can also happen by methods such as possession and control. The next topic within secured transaction that's worth talking about is more or less a rule statement that you should memorize or become familiar with if you are not already. But when multiple parties have an interest, when multiple secured parties have a security interest in the same collateral, the rule that you want to write down is that the first to file or perfect is going to have priority. If none of those parties have in fact perfected, then the first to attach has priority. This has been tested many, many times, so it's a good rule to be familiar with. And then the last thing that is not in your handout, but that I briefly want to discuss, is default. This is a topic that comes up oftentimes. And default is the whole idea of what can a creditor do in the event a debtor defaults on a loan, and those obligations that they must comply with. So again, if you are not familiar with these highly tested topics, basically the basics of Article 9, I would make sure that you practice some past essay questions and look to other resources as well, such as our MEE one-sheets are an excellent resource. Our next subject is trusts. The first most highly tested topic is on the validity of trusts. Most of our MEE answers when they ask this question provide the rule statement that trusts for personal property are valid if there is a trustee, a beneficiary, and trust property. I bring this to your attention because many commercial courses require or teach or put in their outline these really kind of like eloquent, long rule statements about what is required to have a valid trust. And the truth is, those statements are not found in the MEE answers. Again, usually when they test the validity of a trust on an MEE, they want you to say that a trust for personal property is valid if there is a trustee, a beneficiary, and trust property. It's very basic, it's plain language, so don't make it harder than it already is. Just use that language and those words for your rule statement. They also like to test different types of trusts. Specifically, they like to test charitable trusts. Charitable trusts are recognized and they are valid, and they can be created for any charitable purpose so long as it is for a large number of not readily identifiable people. Additionally, even if the specific charitable trust purpose fails, that doesn't necessarily mean that the trust is just going to be extinguished or lapse, so to speak. The doctrine of cypre can be applied to try to save it. And then the third most highly tested topic we see in the subject of trusts are the duties of our trustee, specifically on the investment end. The MEE exam really likes to test the Uniform Prudent Investor Act. Under this obligation, this means that your trustee has a duty to diversify. And more specifically, they have to administer the trust as a prudent person would, using reasonable care, skill, and caution. If someone is claiming that a trustee has, say, breached this duty, it's important to note that the entire portfolio is going to be evaluated to determine whether or not this duty was breached, rather than one specific isolated transaction. Our final subject is wills, or decedent's estates. Many of our wills questions tend to focus on the validity of a will. So it's helpful to know some of the basic requirements to have a valid will. In most states, in order to have a valid will, the person who executed that document must be over the age of 18 and have intended that document to serve as their will. Additionally, wills need to be in writing, signed by the testator, and witnessed. In most jurisdictions, really any mark that was meant to be a signature by the testator will be valid. About half of the states now recognize what we call holographic wills. And this is something that you should discuss if you find that a traditional formal will is not valid based upon your fact pattern. This is because a holographic will is basically an unwitnessed will. And again, about half of our states and jurisdictions recognize holographic wills. Most states that do recognize holographic wills require that this document, of course, be in writing, and that the material portions be in the testator's own handwriting, and that it be signed. Again, this is an unwitnessed document. And then a lot of MEE questions also discuss the dispensing power, which is basically the court's ability to dispense of or to dispose of some of the will formalities in order to be able to probate a document as a valid will. Another highly tested topic within this subject of wills is the Slayer statutes. So what is this all about? Slayer statutes basically state that if someone feloniously and intentionally kills a person, the person that commits that felonious and intentional killing is no longer able to inherit in any way from the person in which they killed. It's also helpful to note that whenever they usually test the Slayer statute on the MEE, the person who does the killing is not barred from inheriting from the person that they killed. And this is usually because the killing is not felonious and intentional. The next topic within wills that's highly tested is intestacy, or intestate succession. This is what you talk about when someone dies without a will. These MEE questions that test intestacy do not focus on math, which is great because many people do not like math and they're not good at it. So the good news is that is not typically the focus when this topic is tested. Instead, when they do test intestacy, they want you to know the different approaches of intestate succession, such as per capita at each generation, as well as per capita with representation. We find that a lot of commercial courses focus a lot on the math with lots of different hypotheticals, and people stress out over that. Instead, shift your focus to the vocabulary and the language that these MEE answers use when this topic is tested. So that wraps up our video on how to pass the multi-state essay examination. We hope that you found it helpful. We have a lot of MEE resources, such as an MEE course, private tutoring, seminars, and MEE one-sheets that receive excellent reviews. Again, those are basically it's technically 2 sheets of paper that talk about all of the highly tested topics within each subject for the MEE. We hope that you found this video helpful, and thanks for tuning in.